Research Institutes of Oslo, uno de los principales, ¿no?, a nivel internacional, instituto de investigación sobre paz, es decir, pues obviamente guerra también. Gregory Reichberg es director de un programa de investigación actualmente intitulado Warring with Machine, Military Application of Artificial Intelligence and the Relevance of Virtue Ethics. Un proyecto de 4 años que es financiado por el programa de investigación sobre las condiciones culturales que subyacen a un cambio social. Gregory Reichberg ha escrito numerosos libros y artículos. Nomás recalco aquí uno de los más recientes, una monografía publicada a Cambridge University Press en 2017 sobre Tomás de Aquino, sobre los textos de Tomás de Aquino sobre guerra y paz. Uno de los títulos que ha sido, pues, que ha ganado varios premios. De 2012 a 2020 estuvo, pues, basado en Oslo y dirigió, pues, la escuela sobre paz y conflictos. De 2009 a 2012 fue director del centro del PRIO, pero esta vez en la isla de Chipre, coordinando estudios y diálogos para, pues, la reunificación de la isla. Y desde 2021, y eso me llena, digamos, de mucha alegría, ha sido, pues, nombrado consultor del dicasterio de la Santa Sede para el Servicio del Desarrollo Humano Integral, con sede, como saben, en la Ciudad de Vaticano, y su contribución a este concilio se centra en el desarme, las implicaciones éticas de las nuevas tecnologías militares y cuestiones más amplias de guerra y paz. Gregory, it's a pleasure really to have you here, and I give you the floor. Thank you so much.
Okay, thanks so much, Mateas, Professor Nebel. Very good to see you. I wish I could be with you in person. I doubly wish I could be speaking in Espanol. The question that is put to me is this: does the ongoing war in Ukraine represent a failure of post-World War II mechanisms to guarantee peace? Well, this could be a very short talk because the simple answer is yes. This does represent a failure. Well, the conference organizers won't be happy if I just end my talk there. So before explaining why it does represent a failure, let me begin by saying a few words about the conflict. In the fall of 2021, Ukrainian officials reported that the Russian government had placed approximately 100,000 troops near the border with Ukraine. On February 21st, 2022, Russian President Vladimir Putin announced that Russia recognized the independence of the separatist Donetsk and Luhansk People's Republics. 3 days later, on February 24th, Russia launched a military attack on Ukraine, reportedly to protect residents of the Donbas region from the Ukrainian government. The invasion has resulted in Russian forces attacking major cities and infrastructure in Ukraine. Attacks by Russian forces have occurred in major cities across Ukraine, including the capital, Kiev. By scope, the war is the largest in Europe since World War II ended in 1945. The Office of the United Nations High Commissioner for Human Rights has verified over 6.3 thousand deaths of civilians in Ukraine during the war as of October of this year. Europe is facing its biggest refugee crisis since the Second World War. More than 7 million people have fled Ukraine, and nearly 7 million Ukrainians are internally displaced. According to UNICEF, every second that passes, a Ukrainian child becomes a refugee. The United Nations Development Program has warned that Ukraine could free fall into poverty. The world's economy has been adversely affected with energy and grain shortages and steep price increases. As usual, the weakest are hit the hardest. The UN Charter lies at the center of the post-World War II security architecture. As noted in its preamble, the Charter aims to respond to the fundamental human aspiration of, and I quote, saving succeeding generations from the scourge of war. By the way, I'm going to come with several quotes from the UN Charter, and I've sent a copy of the quoted passages in Spanish, and I hope they've been put up so you can read them as I quote the passages. I've put them in the order in which I present the passages. The state representatives that signed the charter at the 1945 San Francisco Conference on behalf of their respective peoples made clear that they did so with a firm determination, and another quote, to practice tolerance and live together in peace with one another as good neighbors, end of quote. Thus, among the purposes of the charter, we read in first place, this is Article 1.1, that the charter was established to maintain international peace and security, and to that end to take effective collective measures for the prevention and removal of threats to the peace, and for the suppression of acts of aggression or other breaches of the peace, and to bring about by peaceful means and in conformity with the principles of justice and international law, adjustment or settlement of international disputes or situations which might lead to a breach of the peace. Article 1.1 indicates the mechanisms that in the case of Ukraine manifestly appear to have failed. Have effective collective measures been taken to prevent the outbreak of war in Ukraine? Well, apparently not. Have the disputes that gave rise to the conflict been settled by peaceful means, in conformity with the principles of justice and international law? Definitely not. Furthermore, Article 2.3 stipulates, and I quote again, all members shall settle their international disputes by peaceful means in such manner that international peace and security and justice are not endangered, end of quote. Russia has clearly not followed this obligation, partly under the pretext that its dispute with Ukraine is not an international one. Come back to that later. So what accounts for this twofold failure? First of all, there are two failures. Regarding the failure to peacefully resolve the dispute between Russia and Ukraine, the main responsibility would appear to fall on the UN's main judicial body, the International Court of Justice. And I'll come to the second failure in a moment. Okay, the International Court of Justice is tasked with adjudicating disputes between sovereign states. The court, which was created by the UN Charter, Chapter 14, Article 94, has two relevant clauses. Here I'll quote. First clause, each member of the United Nations undertakes to comply with the decision of the International Court of Justice in any case to which it is a party, end of quote. Now, this is an obligation of a moral kind. There is no straightforward compliance mechanism as in domestic court judgments. In a domestic court judgment, if a party doesn't comply, well, the police follow up. However, the next clause in the Charter passage on the International Court of Justice leaves open the possibility of an indirect compliance mechanism. I quote, "If any party to a case fails to perform the obligations incumbent upon it under a judgment rendered by the court, the other party may have recourse to the Security Council, which may, if it deems necessary, make recommendations or decide upon measures to be taken to give effect to the judgment." End of quote. The supposition here is that the Security Council could force compliance through the imposition of sanctions. Well, on the 26th of February, Ukraine filed an application, February of this year, Ukraine filed an application with the International Court of Justice against Russia concerning a dispute on the interpretation, application, and fulfillment of the Genocide Convention. Ukraine contended that having falsely claimed acts of genocide against the people of the Luhansk and Donetsk Oblasts regions, Russia declared and implemented a special military operation to prevent and punish the purported acts. In response, on the 16th of March, the court issued its decision. By a vote of 13-2, the court ruled that Russia, and I quote, "shall immediately suspend the military operations that it commenced on the 24th of February. The two dissenting opinions were issued by the Russian and Chinese judges on the court. This was the first verdict handed down by the World Court since the Russian invasion began. Before the invasion, Russia did not press its claims against Ukraine in an international court proceeding, at least not to my knowledge. Russia ignored the court's decision, or more precisely, questioned the court's jurisdiction in the case. As we know all too well, Russia did not cease its military campaign. Why did the UN not take steps to enforce the International Court of Justice's ruling, as was provided in Chapter 14, Article 94? Here I quote, "If any party to a case fails to perform the obligations incumbent upon it under a judgment rendered by the court," okay, so in this case, Russia's obligation to desist from military operations against Ukraine, okay? So if a party to a case fails to perform the obligations incumbent upon it, the other party, in this case Ukraine, may have recourse to the Security Council, which may, if it deems necessary, make recommendations or decide upon measures to be taken to give effect to the judgment. End of quote. So why wasn't the ICJ ruling enforced? Ukraine did take its case before the Security Council, but we all know why no measures were implemented against Russia. Being a permanent member of the Council, Russia has veto power over any resolution that might affect it adversely, no matter how justified that resolution might be. Already on February the 26th, Russia vetoed a UN Security Council resolution that would have demanded that Moscow immediately stop its attack on Ukraine and withdraw all troops. End of quote. All right, on this same vote, China, India, and the United Arab Emirates abstained. Could Russia be removed from the Security Council such that a resolution could be enforced? Well, the answer is no. Removal from the Security Council would require a vote of the UN General Assembly based on the recommendation of the Security Council. This has never happened. And given that Russia has a veto on the Security Council, the Council cannot recommend Russia's removal without Russia's agreement. And of course, this simply will not happen. Okay, so thus far we have been considering judicial recourse to the International Court of Justice. Such recourse has been made successfully by Ukraine, but the judgment against Russia cannot be enforced, as we have just seen. Okay, now we come to the second kind of measure at disposal that has been outlined in the UN Charter. Beyond the judicial measures at its disposal through the International Court of Justice, the UN also has a kind of executive political power, enabling it, and now I quote from Article 1.1 of the Charter, okay, the UN has a power enabling it, I quote, to take effective collective measures for the removal of threats to the peace and for the suppression of acts of aggression or other breaches of the peace. The executive power, executive political power, just described, is allocated to the UN Security Council, which, according to Chapter 5, Article 24.1, has, I quote, primary responsibility for the maintenance of peace and security. Okay, so this responsibility, this primary responsibility, falls on the Security Council. Well, the executive and political extrajudicial powers of the UN are outlined in Chapter 7 of the Charter, action with respect to threats to the peace, breaches of the peace, and acts of aggression. So let's consider for a moment the provisions of Chapter 7. Okay, first of all, there's Article 39. The Security Council shall determine the existence of any threat to the peace, breach of the peace, or act of aggression, and shall make recommendations or decide what measures shall be taken in accordance with Articles 41 and 42 to maintain or restore international peace and security. Notice that here the UN acts through a Security Council, which collectively makes a political decision that there exists either, and there are three options outlined, that there exists a threat to the peace, namely a situation that if left unchecked will likely result in an outbreak of war. In other words, an impending armed conflict. Second, a breach of the peace. For instance, hostilities between armed units of two states or a serious treaty violation. And then third, aggression, namely a wrongful application, direct or indirect, of force by one state party against another. Every act of aggression constitutes a breach of the peace. So when the Security Council determines that an act of aggression has occurred, it reaches a political, not a judicial finding. And this political finding opens, and I quote from a leading commentator on the Charter, Bruno Sima, such a finding opens the way to enforcement action and helps unite the international community against the aggressor. End of quote. So the Ukraine conflict exemplifies the third of the three categories just mentioned, namely aggression. The conflict began with verbal aggression, threats against the territorial integrity of Ukraine, and was consummated by actual invasion. This seems to be a textbook case of aggression. Russia, of course, views the matter differently. It claims that Ukrainian actions in the Donbas region, okay, alleged ethnic cleansing by Ukraine against ethnic Russians in the area. So Russia claims that Ukrainian actions constituted a threat to the peace that had to be stopped. In other words, Russia appealed to what has since come to be called a right to humanitarian intervention. Okay, so what measures could the Security Council have adopted in the face of this aggression? Okay, there are two measures outlined. It's Article 41, and then there's Article 42, Chapter 7. Okay, Article 41. The Security Council may decide what measures not involving the use of armed force are to be employed to give effect to its decisions, and it may call upon the members of the United Nations to apply such measures. These may include complete or partial interruption of economic relations and of rails, sea, air, postal, telegraphic, radio, and other means of communication, and the severance of diplomatic relations. So basically what we're talking about here in Article 41 are economic and related sanctions. Then there's Article 42. Should the Security Council consider that measures provided for in Article 41 would be inadequate or have proved to be inadequate, it may take such action by air, sea, or land forces as may be necessary to maintain or restore international peace and security. Such action may include demonstrations, blockade, and other operations by air, sea, or land forces, or members of the United Nations. Okay, all of this is a euphemism for employment of armed force, namely acts of war in support of UN norms. So, in principle then, the Security Council could have imposed economic and related sanctions against Russia, and should these sanctions have proved inadequate to stop Russia's military offensive in Ukraine, the Security Council could have authorized its member states to use armed force to halt this offensive. The Security Council has a very broad mandate in this regard. Well, we all know that the Security Council has had no recourse to the measures just outlined. The reasons are twofold. First, Russia exercises a veto and will allow no measure that would counter its special military operation in Ukraine, as it calls its war effort. Okay, so Russia exercises a veto. Second, Russia possesses a large arsenal of nuclear weapons. A use of force against Russia under UN mandate could trigger a Russian nuclear response. Russia has warned as much. These two causes, the veto and Russia's possession of a nuclear weapon, together account for the failure of the UN security architecture to address the conflict in Ukraine. Both causes of failure are systemic in character. The UN Charter, like so many other international agreements, involves fundamental compromises that were necessary for reaching the needed consensus on key points. Generally speaking, every important international agreement is dependent on historical contingencies. This is also the case for important domestic agreements and constitutions. For instance, think of the US Constitution, which enshrines the right for the citizenry to bear arms. Right? A lot of people think that was set in an historical context which no longer coincides with our current conditions. Well, the UN Charter is similarly beset by such contingencies. The veto arrangement for the Security Council represents one such contingency. If the Charter were negotiated today, a very different outcome could be expected. Security Council reforms have been proposed, but none have been implemented. The effectiveness of the Security Council as a guarantor of international security is hamstrung due to the veto arrangement that was written into the Charter. Here, I can quote from Chapter 5, Article 27.3. Decisions of the Security Council shall be made by an affirmative vote of 9 members, including the concurring votes of the permanent members. Oh well, the word veto is not mentioned, but it is implied. A veto blocks a proposed substantive decision of the Security Council. A veto prevents, at a given date and with regard to a given situation, the coming into existence of a proposed written expression of the collective political will of the Security Council pertaining to the Security Council's primary responsibility for the maintenance of international peace and security. In the process of leading up to the adoption of the Charter, the veto power of the permanent members was opposed by some small and medium-sized states. As this veto power is manifestly inconsistent with what became Article 2.1 of the Charter's first chapter. And I quote, "The organization, that is to say the UN, is based on the sovereign equality of all its members." End of quote. But the heavies at the San Francisco conference made clear that acceptance of the veto formula without any changes was a condition sine qua non for the adoption of the Charter. Well, so manifestly some members are more equal than others. In the period running up to adoption of the UN Charter, there was an interesting disagreement concerning the conduct to be expected of a permanent member if it was involved as a party to a dispute. Okay, as Russia today is involved as a party in dispute vis-a-vis Ukraine. The United Kingdom at the time favored a general obligation for such a party to abstain, whereas the Soviet Union held the diametrically opposed decision, namely that the principle of unanimity should be strictly observed. It was the Soviet Union's view that ultimately prevailed with the concurrence of the US. Had Britain's proposal been followed, Russia would not now be allowed to exercise a veto on a matter directly concerning itself. So this, I think, is a serious flaw in the UN Charter. As we have seen time and again over the last 70 or so years, the veto power conferred on the 5 permanent members, even in matters concerning themselves, has proven to be, well, as I just noted, a serious flaw, hampering effective Security Council action when needed. Moreover, the other reason for failure, namely Russia's continued possession of nuclear weapons, also represents a systemic flaw in the international security architecture. In the Treaty on the Non-Proliferation of Nuclear Weapons, signed in 1968, we read Article 4. I wasn't able to bring this up in Spanish, so I just put it down in English. I quote, "Each of the parties to the treaty undertakes to pursue negotiations in good faith on a treaty on general and complete disarmament under strict and effective international control." Such negotiations have regrettably not happened. The 5 permanent members of the Security Council continue to possess their nuclear weapons as before. Adding insult to injury, these members have refrained from participation in the recent treaty that outlaws possession of nuclear weapons, namely the 2017 Treaty on the Prohibition of Nuclear Weapons. The 5 permanent members of the Security Council even refused to take part in the discussions that led to adoption of this treaty. Not exactly a show of good faith as required by the earlier treaty, the Nuclear Non-Proliferation Treaty. As a result of the present conflict, not only Ukraine, but also the surrounding countries are at risk of suffering the devastating effects of a nuclear attack. We are all held hostage to the unfolding crisis. I count myself in the we, sitting as I am here in Oslo, Norway. Norwegian school children have now been distributed potassium iodide pills that protects against radiation sickness. I've got a 14-year-old son. He's gotten these pills. And we were being told to identify bomb shelter locations in our neighborhoods to keep stockpiles of essential goods and so forth. For me, this is a throwback to my youth in the years after the Cuban Missile Crisis. I still remember writing a poem in the 2nd grade about the hydrogen bomb. It is an illusion that countries of the region are protected by a so-called nuclear umbrella, NATO's nuclear umbrella. There exists no such umbrella. Rather, we live under the hope that possession of nuclear weapons by one country will dissuade another country from launching a nuclear attack, because such an attack would be met by nuclear retaliation. This is the theory of nuclear deterrence. Whether this amounts to a well-founded hope, I have my serious doubts. The only certain way to secure safety from nuclear weapons is to get rid of them entirely. And this is an area that I've had the pleasure of researching together with Professor Nebo. Okay, now to conclude on the failure, the twofold failure, as I'm calling it. So, the international security architecture has failed to address the current crisis in an effective manner. This results, as we have seen, from three systemic flaws. No internationally enforceable dispute settlement procedure. Okay, we've got the International Court of Justice, but there's really no way to enforce its decisions. That's first. Second, the veto power of the 5 permanent members of the Security Council. So whenever these members are directly involved in a dispute or have a strong national interest in one, the veto can and will be used, thus paralyzing remedial action. And third, the ever-looming threat of nuclear escalation, which likewise hinders remedial action. Okay, so overall, the international security framework, architecture, has failed. But there have been some measures undertaken with a limited impact. These impacts include the Black Sea Grain Initiative, overseen by the UN and signed 22nd of July by Ukraine, Russia, and Turkey. This is an agreement on the resumption of Ukrainian grain exports via the Black Sea amid the ongoing war. Since then, exports have proceeded from the Ukrainian port of Odessa, carrying grain under the deal. Just recently, however, Ukrainian President Zelensky has complained that Russia is failing to fully implement the agreement. A large number of ships are awaiting permission to set sail with their cargoes of grain. Ukraine, as we know, is one of the biggest suppliers of grain in the world today. The populations of the Middle East and the Horn of Africa depend on these exports, and many face possible starvation without the needed grain being exported. Okay, another measure that is, well, proven to be of limited success is the protection of nuclear power plants. The International Atomic Energy Agency, an associate organization of the UN, has taken steps to safeguard the Zaporizhzhia nuclear power plant. I've surely mispronounced it, by the way, but okay, well, steps have been taken to assure the safety of this nuclear power plant, including site visits by IAEA inspectors. Built during the Soviet era and one of the 10 biggest nuclear power generation plants in the world, this plant has been engulfed by fighting between Russian and Ukrainian troops, fueling concerns of a nuclear catastrophe. This is an unprecedented crisis. Never before have armed hostilities been conducted in close proximity to nuclear reactors. Ukrainians continue to operate the plant under Russian control. The IAEA has engaged in discussions with the two sides, urging that the plant be placed under direct supervision of international authorities. But this, so far, Russia has not agreed to. The reactors at the plant are no longer operational, but the spent highly radioactive fuel rods and reactor cores require constant electricity to stay cooled. Should the electricity fail, or should munitions penetrate the cement chambers in which these radioactive materials are stored, a dangerous leakage could occur, similar to what happened in Chernobyl in 1986. And just to remind you that the meltdown that occurred in 1986 had widespread effects throughout the region. I mean, just in Norway, for instance, herds of reindeer in the north of Norway had to be slaughtered as they were contaminated from eating vegetation that had been affected by radioactive fallout. Okay, now, I've talked about the failure of the architecture. I've talked a bit about some ways in which the architecture has had an impact. should also mention the importance of symbolic measures. The post-World War II security architecture includes more than a set of measures for conflict prevention and mitigation. Important, it also includes a normative framework for thinking about justified versus unjustified uses of armed force, and a set of agreed-upon principles for differentiating differentiating justified versus just unjustified uses of armed force in concrete settings. So the UN Charter lays out a roadmap for assessing, legally and morally, the possible uses of armed force in today's world. The Charter rejects the main assumptions that guided strategic thinking by states in the preceding period. Under classical international law, which prevailed from the late 18th to the early 20th century, war was viewed as an acceptable conflict resolution tool. If a state was unable to find satisfaction by means of negotiation or arbitration for some wrong done to it by another state, the wrong state was entitled to declare war to press its claim. It was thought that war could serve as a substitute for the adjudication of a judge or a negotiated agreement. By a tacit understanding between states, right would vest in the party that prevailed on the battlefield. Success on the battlefield would settle the matter under contention. Vladimir Putin appears to be operating from this now antiquated mindset. He pressed Ukraine with claims about perceived wrongs. Well, NATO expansion to possibly include Ukraine, prejudicial treatment of Russian speakers in Ukraine, violation of the Minsk agreements, etc. Okay, so he pressed a set of claims. When a settlement on these points was not reached to Russia's satisfaction, it responded with threats of invasion, and when these threats failed, it invaded. But in so doing, Putin has rejected. Worse, he has flagrantly violated the normative core of the post-World War II architecture. According to this normative core, war cannot be resorted to as a measure to resolve a dispute in one's favor. So while the UN has been largely powerless to stop Putin's invasion for the reasons given earlier, it has made effective use of the UN has made effective use of symbolic measures to indicate how flagrantly Russia has violated the fundamental norms of international society. Here are a few symbolic gestures that I found noted on the UN's website. Well, on the 20th of February, the prosecutor of the International Criminal Court opened an investigation for war crimes and crimes against humanity. On the 2nd of March, the United Nations General Assembly issued a resolution deploring aggression committed by Russia against Ukraine. There was 141 votes in favor, 5 against, 35 abstentions. Well, the UN Rights Council adopted a resolution on 4 March calling for the swift and verifiable withdrawal of Russian troops and Russian-backed armed groups from the entire territory of Ukraine. Okay, and the list goes on from there. Most recently, the UN General Assembly adopted a new resolution calling on the 5 permanent members of the Security Council to justify the use of the veto. All of these measures, although largely symbolic, are not without value, far from it. They have been enacted through established and credible channels, and this is reflective of a shared commitment to international order. Rarely, if ever, since the end of the Second World War has there been such a widespread consensus condemning violation of agreed-upon norms. Even Switzerland, long a bastion of neutrality, has applied EU-led economic sanctions against Russia. And I mention this as illustrative. The examples could be multiplied. Okay, time is running short. Here I could have a lot to say about the Charter's specific rules governing resort to armed force. These rules enable us to differentiate between aggression and legitimate uses of armed force. And there are really two key clauses. Well, there's Chapter 1, Article 2.4, and Chapter 7, Article 51. Article 2.4 presents the core prohibition in the Charter. All members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the purposes of the United Nations. End of quote. This prohibition is very broad. Not only does it exclude use of force against the territorial integrity of another state, but threats of force as well. So prohibited is not just the use of physical force through bombing, troop movements, or other such violent means to make another party do what it refuses to do, but also prohibited is coercion, namely incentivizing the other party through threats of future harm to undertake actions that it would rather not do. The Russian campaign against Ukraine started with coercion, namely threats conveyed in word and action, and then moved on to actual physical force. It's not clear, to me anyway, that the invasion of Ukraine was planned from the beginning. More likely, on my view, Putin expected his attempted coercion would succeed, that his threats would succeed, but then when the threats didn't succeed, to preserve his credibility, he felt compelled to follow through on his earlier threats. You know the phrase, be careful what you wish for? Well, it's also true, be careful what you threaten, because you might have to follow through on your threat, even if that's not what you originally intended. Okay, then there's Article 51. The previous article was the core prohibition. Article 51 points to the Charter's key permission. I read, nothing in the present Charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations until the Security Council has taken measures necessary to maintain international peace and security. Unlike Article 2.4, which I just read earlier, a moment ago, which as we saw is very broad in scope, Article 51 is very narrow. Armed force cannot be deployed against a threat. So when Russia threatened Ukraine, Ukraine would not have been entitled to attack it in return. Armed force can be deployed defensively only to counter an attack that is just beginning or is ongoing. A country can use defensive force solely to counter a present wrong. This condition looks to the proximate cause of war. An attack has been made. Appeal cannot be made to this principle, to Article 51, appeal cannot be made in this context to remote causes of a war. So you can't justify defensive resort to force by appeal to something that happened long ago in the past. Russia's claim that it was forced to attack Ukraine because of Ukraine's solidarity with NATO expansion, the admittance of the Baltic republics, simply does not hold water as a justification for Russia's attack on Ukraine. No more than Hitler's grievances regarding the Versailles Treaty justified its attack on Poland. So what I'm trying to say here is that remote causes of war, even when true, even when they happened, the Versailles Treaty was unjustifiable in many of its terms. But even when true, these remote causes of war do not trigger a permission to use force as stipulated by Article 51. So Russia cannot appeal to Article 51 to justify its invasion of Ukraine. Ukraine, by contrast, can appeal to Article 51 to justify its resort to armed force and to seek help in countering the aggression from its allies or friends. Okay, I've come to the conclusion. In what has been said thus far, I've tried to answer the question put to me. Does the ongoing war in Ukraine represent a failure of post-World War II mechanisms to guarantee peace? All right, well, the answer has been a resounding yes. This notwithstanding, the million-dollar question still looms. What follows now? What, if anything, can bring this war to a close? Well, to answer this question, principles of justice will not be front and center, because the outcome of wars depends on might, and might is not always aligned with right. Sometimes might is aligned with right, sometimes it isn't. Often it isn't. Nor is peace necessarily aligned with full-blown justice. Justice, when pushed too hard, can be an impediment to peace. Sometimes it is said that our aim should not be the realization of any peace whatsoever, but solely the realization of a just peace. But insisting too much on a just peace can undermine the more minimal peace that is within our reach. Best can become the enemy of the good. In this war, it is unlikely that either side will achieve a decisive military victory. At some point, sooner I hope than later, the conflict will be taken up at the negotiation table. Compromises will have to be made by both sides in the interests of peace. It is essential that the international community, ideally under the auspices of the United Nations, but with the support of major powers such as the US, China, the EU, and Turkey, should press the parties to see how their mutual interest and our common good lies in peace. To achieve this peace, compromises should not be swallowed at any cost, but inversely, nor should we expect that this peace should be perfectly aligned with justice and nothing less. All right, well, thanks so much for listening to me.
Gregory, for this conference that certainly shows us first your knowledge and master understanding of the conflict, and shows obviously also the difficulty in which we are today, a difficulty where a major power, a member of the Security Council, a nuclear power is actually violating the very core of the UN Charter. So I'll open the floor to question. Voy a abrir el paso pues a preguntas. Hay varios estudiantes aquí, pues los invito realmente a aprovechar de la expertise, de Gregory Heichberg sobre estas preguntas, Me parece muy interesante, la última conclusión, Hay una tensión entre paz y justicia, entre la búsqueda de una paz justa y la búsqueda de al menos algunos elementos de paz. Y el conflicto de Ucrania pues deja la pregunta no a un nivel teórico, pero a un nivel muy práctico, Cómo salir del conflicto en el cual estamos. Y eso obviamente es una pregunta fundamental. Una segunda pregunta es cómo remediar a la incapacidad que tiene el mecanismo que tenemos, que no es un mal mecanismo, pero es el único mecanismo que tenemos, pero que tiene limitaciones obvias. Cómo salir de estas limitaciones para poder digamos, evitar este tipo de conflictos a futuro. Abro la pregunta a la sala. No sé si hay alguien que quiera tomar primero la palabra. El entusiasmo delirante siempre de las primeras preguntas me llama la atención, ¿no? Nadie. It will be easier, I think, for Gregory if you speak in English.
Well, my name is Ignacio Cosido. I am professor of the University Francisco de Vitoria in Madrid. And first of all, congratulations for these excellent lessons about international law and the United Nations system. It's just to ask you if you can develop a little bit more the last point of the negotiation in the Ukraine conflict. From your experience and from your knowledge, could you say something about how can you imagine these negotiations in terms of timing, in terms of conditions, and in terms of results of this negotiation? So I know it's a difficult question right now, but if you could say just some idea about that, will be very useful. So thank you so much.
Yeah.
Well,
Would you like me to respond? I didn't understand the previous two questions because they were put in Spanish. Would you like me to just go ahead and respond to this one?
yes.
I mean, you know, what has me worried in the present conflict, among other things, is the fact that the outrage that the world feels, for good reason, certainly Ukraine's outrage, and the clear violations of justice, as I've indicated, raising all those points it's not always helpful when it comes to finding a way out of the conflict. And it's position taken by the U.S. By the U.S. Leadership is that it's up to Ukraine to decide whether it wants to negotiate, when it negotiates, and how it negotiates. But I think at the end of the day, in this current conflict, Ukraine is not going to be able to regain all that it has lost. It seems extremely unlikely that Ukraine will be able to prevail militarily over Russia. I mean, Ukraine might be able to press Russia out of the areas that it's currently in. It seems to be succeeding in doing so. And even if it manages to press Russia rather entirely out, which seems unlikely, but even if it managed to do so, still Russia will still be a potent military force, and Russia will be able to continue its bombing of Ukrainian targets, for instance. So I think given the fact that there will not be a clear victor in this conflict, the parties need to be strongly encouraged to engage in negotiations. And, at some point in time, pressure will have to be brought to bear to this effect. Otherwise, I just don't see a solution in sight. Russia, at some point, after suffering serious military setbacks. I mean, it's already suffered them. It too will begin to experience the pressure to negotiate and to adjust its demands downward. But just to again sum up what has me really worried here is, during the Second World War, the Allies put forward a demand of unconditional surrender vis-a-vis Germany. And a lot of people think that the war persisted as long as it did and became as bloody as it did. And the destruction was wrought to the degree, to the degree to happen because the German leadership was given no way out. And so, it had to be a fight to the bitter end. I don't think it would be a good thing if we press justice to the point that no compromises vis-a-vis Russian demands are made. Now, how to get the parties to adjust their demands downward, to adjust their expectations downward, so that some kind of meaningful negotiation can take place? I wish I had the answer to that. What does seem really important to me is that serious preparatory work be made, because a moment may come sooner than anticipated. Perhaps there will be some sort of military moment when there's a turning in a significant turning on the battlefield. If preparations haven't been made, then it would be hard to capitalize on the opportunities that might arise in such a moment. So I hope I've said a few words to, in response to your question. What the specifics would look like, I'm not able to say. But the world, there have been examples of very serious conflicts that have ended through negotiation. Most of the conflicts in recent years have been intrastate conflicts within states, of opposing communities or factions. But I think some of the lessons we've learned from some of these intrastate conflicts and successful negotiated outcomes could perhaps be applied in the present case. Lessons learned applied to the present case.
Thank you very much, Gregory. We have time for another question or another set of questions. Please.
Populations. Well,
Gregory, thank you for your lecture. I'm not able to answer the questions that you did and also Matthias did, but I want to do another question. I'm thinking that we are thinking about authorities and also the international organizations, and maybe we are not doing the best work with these themes and topics. But I remember an article that you wrote, and you said about the military prudence, and you said in this article that in the case of Aristotle, says that the purpose of the armed forces is the achievement or the military victory, and in the case of St. Thomas Aquinas, you said that the purpose is the common good. Now, with this lecture that you are giving today to us, you said the ideas of the peace and the justice. Do you think that the idea, in this case, in Thomas Aquinas, the military prudence in the case of the common good is the peace and the justice? I think that maybe is something utopic working with the armed forces, but I remember a talk that we have, Matthias and I, with Laurie Nathan, and he says that he worked with the armed forces of South Africa, and they changed the vision, and they are working now in South Africa about the common good, like peace and justice. Thank you.
Would you like me to respond?
Yes, please.
No, thanks for bringing out that quote. I haven't thought about that one in a while, and I think it sums up maybe the last point that I was trying to make, that we can prosecute justice to the point that it endangers the common good. And you know, the relationship between justice and peace is not always an easy one. They're not always perfectly coextensive, the one with the other. You know, Thomas Aquinas said that sometimes in the interests of peace, we should forego punishment, where punishment is actually due. Here again, I mean, Russia has done terrible things. Someone asked me to comment on, you know, aggression against civilian populations. I mean, it's really terrible to see people's homes being destroyed with the people in them. I mean, there's no justification for that whatsoever. But by the same token, if Russia's guilt is pushed to the point where Russia has no, and when I say Russia, I mean the leadership. They've got really nothing left to lose. There will be no end in sight to the conflict. So in that sense, you know, going back to the quote, military victory, even when in the interest of justice, cannot be the final word. There's the final word has to be what befits the common good. You know, well, what befits peace.
Thank you, Gregory. I just wanted to add a question of mine, if I can. The Western allies, you know, have been well, sending arms, and are sending arms and credits in huge numbers and increasing numbers. Also in quality, in power, the arms, we are basically also feeding the conflict and making the conflict potentially more dangerous, you know, because it becomes a proxy conflict between Russia and the West, you know, and especially, obviously, the US. So, what have you to say to this policy, you know, of armament of Ukraine by the Western powers?
The principle, I think it's a good thing. It's needed. I mean, Ukraine has been violently attacked. It deserves better. It's entitled to self-defense and to receive aid in doing so. But as you indicate, it's true that this has perpetuated a conflict that might have ended sooner. But it's clear if it had ended sooner, it would have been sort of on Russian terms, which is not a good thing. It's not acceptable. Where where I do have I can raise a question, if I can put it that way, is that, the stated U.S. position is that it's, solely up to Ukraine when to negotiate, how to negotiate, what terms to negotiate on. And I can see why that's being said. The U.S. doesn't want to undermine the Ukrainian war effort, but on the other hand, it's disingenuous because in large respects, the U.S. is making it possible for Ukraine to continue this conflict. The U.S. is, well, in not exactly, but almost a co-belligerent, has become so. Not in formal legal terms, but in some measure. So I think that the U.S. has to be careful not to push this too far. I think that the hope is that Ukraine will solidify some of its gains before the winter sets in. And this can provide a basis for the inception of negotiations, right? Because understandably, Ukrainian leadership does not want to negotiate at a disadvantage. So the stronger their position is going into a negotiation, the better it will be. But I do think that the U.S. has to get involved in sort of promoting peace more than maybe it is at least overtly done so thus far. And I'm sure you noticed that there's a kind of sort of a debate that's now underway in the U.S. and oddly, Republicans on the I don't want to say the far right, but towards in that direction, and then very progressive Democrats are starting to say the same thing, namely that the U.S. can't keep fueling this war indefinitely, that some limits have to be placed on it. And this does not seem unreasonable to me, although it's just currently it's politically unacceptable to say so, because one gets hit with criticisms of appeasement, things like that, statements of that sort.
Very much, Gregory. I think we will bring this first session to a close. Vamos a cerrar pues esta primera sesión y dar paso pues al evento que sigue, es decir, las mesas redondas pues que van a retomar pues la misma temática, ¿no? Pero esta vez del punto de vista positivo, ¿no? Es decir, un esfuerzo de imaginación sobre qué tipo de mecanismos de paz podrían, digamos, permitir evitar conflictos a nivel internacional en un mundo crecientemente multipolar. Pues invito aquí al podio al decano Hermínio